Good afternoon and welcome to the California Office of Tax Appeals. My name is Hofsep Hakopchikian and I am the lead administrative law judge for purposes of conducting this hearing. With me are administrative law judges Sarah Hosey and Shireen Ridenauer. Also present is our stenographer, Ms. Alonzo, who is reporting this hearing verbatim. To ensure we have an accurate record, we ask that you all speak one at a time and do not speak over each other. Also, please do your best to speak clearly and loudly. When needed, Ms. Alonzo will stop the hearing and ask for clarification. After the hearing, Ms. Alonzo will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. The hearing transcript and the video recording are part of the public record. To ensure the hearing runs as smoothly as possible, I would like to offer a few general rules before we go on the record. Please state your name each time before you speak. Please mute your microphone if you are not speaking so that we avoid background noises. Please do not use the WebEx chat feature, which should be disabled. Please be courteous to each other and the judges. Each side will have the opportunity to be heard, so please wait for your turn to make your presentation. This proceeding is being broadcast live, so please do not share any confidential information during your presentation. Also, any information you share on your screen is publicly viewable. Lastly, as a reminder, the Office of Tax Appeals is not a court. We are an independent and impartial appeals body staffed by tax experts. We do not work for or with the state's tax agencies, including the Franchise Tax Board. Are there any questions before we go on the record? Hearing none, I will now ask our technology team and Ms. Alonzo if we are ready to go on the record. Thank you. Everyone's ready. Let's proceed. We are going on the record in the appeal of C. Hyatt before the Office of Tax Appeals. The OTA case number is 210-78175. Today is Tuesday, September 27, 2022, and the time is approximately 1:38 p.m. We are holding this appeal electronically via WebEx. This appeal is being heard by a panel of 3 administrative law judges. My name is Hofsep Hakopchikian, and I am the lead judge for purposes of conducting this hearing. Judges Sarah Hosey and Shireen Ridenauer are the other members of this panel. All 3 judges are equal decision makers. Although I am the lead judge for purposes of conducting this hearing, any judge on this panel may ask questions or otherwise participate to make sure we have all the information we need to decide this appeal. Now, for introduction, will the parties please identify yourself by stating your name for the record, beginning with appellant.
Cliff Hyatt, appellant.
For FTB.
Joel Smith for FTB.
Natasha Page for the FTB.
Thank you all. As discussed and agreed upon by the parties at the pre-hearing conference on September 7, 2022, and as noted in my pre-hearing conference minutes and orders, the issue in this appeal is whether appellant's claims for refund for the 2011, 2012, and 2013 tax years are time-barred by the statute of limitations. With respect to the evidentiary record, FTB provided Exhibits A through N during the briefing process. Appellant did not object to the admissibility of these exhibits at the pre-hearing conference. After the conference, FTB submitted one more exhibit, Exhibit O, which are collection notices that FTB issued to Mr. Hyatt. Mr. Hyatt, do you have any objection to Exhibit O?
No.
All of FTB's exhibits, that is Exhibits A through O, are entered into the record. With respect to the appellant provided Exhibits A through F during the briefing process, which I relabeled as Exhibits 1 through 6 during the pre-hearing conference, so as to avoid any confusion between FTB's exhibits, which are labeled using letters, and appellant's exhibits, which are labeled using numbers. FTB did not object to the admissibility of these exhibits at the pre-hearing conference. After the conference, appellant submitted one more exhibit, Exhibit 7, which is a 4-page document containing FTB's internal comments about appellant's account. Does the FTB have any objection to this exhibit?
Joel Smith, FTB does not have any objections.
Thank you. All of appellant's exhibits, that is exhibits 1 through 7, are entered into the record. Lastly, as discussed, appellant will testify as a witness at this hearing. This oral hearing will begin with appellant's presentation, including his testimony, for a total of up to 30 minutes. Does anyone have any questions before I swear in Mr. Hyatt for his testimony? Hearing none. Mr. Hyatt, will you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth during your testimony?
I do.
Thank you, Mr. Hyatt. Please proceed with your presentation when you are ready.
Thank you, Your Honors. This started for me in November of 2020. I received a letter from my bank that FTB was attempting to seize over $100,000 in 2 accounts owned by my 98-year-old aunt. I am the primary caregiver for my aunt. She happens to be 100 years old now, so she's still going. These accounts were 2 accounts that were in a joint status. She also had accounts in her own name, but these particular accounts were joint status accounts because I needed to have access to that money in the event of her death and the power of attorney expired. I called FTB on December 1st, 2020, and spoke to Jennifer Sorensen, Senior Compliance Rep for Complex Accounts, about this situation. She has handled my accounts at FTB apparently for several years. It's the first time I'd spoken to her, though. I explained to her that I was unemployed since 2010 and had virtually no income until 2017. Ms. Sorensen reviewed my account and informed me that FTP records showed income for me from 2011 to 2017. Ms. Sorensen explained that this income had been estimated based on the payment of mortgage interest on my home, my payment of mortgage interest on my home. This home in Los Angeles was foreclosed on in 2015. Ms. Sorensen confirmed that there were no records of any hard income, that is, any income documented on W-2s or 1099s, and that tax liability was solely created out of my ability to pay my mortgage. She also said that the current collection efforts on my aunt's accounts were the result of income created from 2013 through 2016. Ms. Sorensen indicated that if this were true, that if what I was telling her was true, that I was unemployed during these years, that I had actually no tax liability from 2013 through 2016, she would release the levies on my aunt's accounts, which of course pleased me at the time. That's when it occurred to me, what about 2011 and 2012? Remember, she had said that this particular levy was based on 2013 through 2016. I was unemployed those 2 years, 11 and 12, and I never paid any taxes or filed any returns those years. That's when Ms. Sorensen told me that money from the foreclosure of my home in 2015 was used to pay the fictitious tax liabilities for 2011 and 2012. I asked her if I could get that money back, and she said she'd look into it. Let's take a look at Exhibit 7 now, if you may. Exhibit 7 is a 4-page document. It's entitled Account Comments. And this is a document that was presented to me in discovery by FTB. It reflects comments that are made ostensibly contemporaneously by people who worked on my account at various points in time. As you see in the left-hand side, the left-hand column, you see a date, see number of dates. And then you also see further across from left to right, a user identifier. That's ostensibly the person who is making the comments. And then in the note text boxes, you see the actual comments being made. I want to draw the panel's attention to basically the center of this exhibit, of the first page of this exhibit, which I've labeled Exhibit 7.1. The date is 12/1/2020. And you can see the user or the author of these comments is Jennifer Sorensen. And then there's a bunch of text to the right. And basically, if you read that text from that box and the box right below it, and the box below that, it confirms what I just testified to. But let me highlight a couple of points here. In the middle of the second box of that date, 12/1/2020, she states that based on this information and no hard income, we can abate tax years 2013 through 2016. So again, she's following along what I had told her during the conversation, during our phone conversation, that I was unemployed during those years, didn't file any returns. Further down, she states, I quote, debtor is also questioning the assessments on the 2010 to 2012 tax years that were paid through the EP claim. Advised that 2010 tax year was based on hard income. As an aside, I actually told her I was working 2010. That was my last year. So I had income that year. Back to her statements, quote, he indicated that this was the last year he worked and had the partnership. Tax years 11 and 12 based on estimated income only, with no hard income. And again, the debtor, now we go to the next box because it sort of runs, had no income those tax years, so should not have to file. We have a large amount of payments on those tax years. We'll look into the source of these payments and whether can we reverse the assessments for a refund. Explained SOL, which is statute of limitations. So I think that generally confirms what I testified to earlier, that this is the conversation I had with Jennifer Sorensen, and she documented it in the books and records of FTB. I'd like you next to turn the page to the second page of Exhibit 7. And if you look at the very top, you'll see a couple other entries. The first two by Jennifer Sorensen, where she states, I requested to release, quote, I requested to release the statute of limitations and a refund of over a certain amount of $60,342.40 for the 2012 tax year and $57,758.77 on tax year of 11. So you can see what's going on now. About 3 weeks later, she has reviewed my records, has confirmed that I was not making any income those years, and is now seeking to refund the money that was taken during those 2 years. She actually goes on a little further, I think in the next entry, and she also looks at tax year 2013 as well, $1,096. Even more importantly, if you go further down to the 1, 2, 3, 4, 5, fifth box, okay, and the date here is January 5th, 2021, she submits a request to her lead. Her lead is her supervisor. A request to her lead via email to authorize a statute of limitations refund and a refund done and approved as the debtor had no filing requirement, need to refund payments to the collections, statute of limitation refunds needed as follows for tax year 2011, $57,758.77, tax year 2012, $60,342.40, tax year 2013, $2,733.32. This reflects the money that I'm seeking returned to me in this claim in the course of this appeal. Okay, so now what we have here is the refund being processed within complex accounts, the area that had jurisdiction over my accounts during this period. And you see the box just below that, there's an entry by Sharon De Los Santos. Now, I don't know who Sharon De Los Santos is. I've never spoken to her. I've spoken to Jennifer Sorensen several times, but never to Sharon De Los Santos. But she apparently, through the org charts that have been provided to me, also worked in complex accounts. Jennifer Sorensen was a senior compliance officer, compliance rep. Sharon was a principal compliance rep, which I believe is senior to a senior compliance rep. And she states in her entry, completed requests for tax years 11 through 13, Per collector, Jennifer Sorensen. Sorensen is considered the collector. No filing requirement, and balances were based on OL, which I believe is my occupational license. We'll ask co-lead to approve to allow the refunds to be issued. So this matter is now percolating further up the chain within complex accounts. It appears that one lead has approved it, and now it's going to another lead. The next important entry with respect to this case is further down on the same page, second page of Exhibit 7, number 6. Excuse me, I'm sorry. The date is January 20th, 2021. This is an entry by Leslie Yorkston. Leslie Yorkston is a person who works in a department called Collection Advisory Team, CAT. All right. Here's what Leslie Yorkston says. Do not allow, quote, do not allow for the 2011 to 2013 tax years to override the statute of limitations. The funds are statute of limitations and are not to be refunded. The 2011 through 2013 tax years were overpaid by the taxpayer. They were not collected by FTB. And that's the only entry that I see in this entire document, that I see in the entire record, books and records of FTB, that indicates a denial of my claim. Now, who is Leslie Yorkston? I was not able to speak to Leslie Yorkston. She'd be certainly a good person to depose when we get to civil discovery, but it appears that she's someone who works in CAT, and she also appears to be a person who was involved in the obtainment of the foreclosure funds. If you look on the very first page of this exhibit, you see her name appear several times from 2015, when my house was foreclosed on. Now, the question I have is she the only person who decided this claim should be denied? Is she an attorney? Was this claim ever reviewed by attorneys inside FTB? I see no record of it. I see no record in the account comments of any attorney review. I see no record in the privilege log of any attorney review. Again, these are very important issues, I think, for later civil discovery. Okay, that completes the first part of my analysis. My analysis, I should have mentioned, is really in two parts. This is the factual part. My next part is the legal part, my legal analysis, which I've covered in the slide that I handed over to you, the hearing aid. Does the panel have this hearing aid? Good, thank you. We can go through this. This will make it a little easy as an outline to go through basically the legal arguments. First of all, with respect to the factual chronology, does anybody have any questions? Okay, thank you. All right. So in a case like this, it seems like the clearest thing to do is to start right with the statute of limitations, as it applies to FTB. I'm sure you folks have had plenty of opportunities to look at this. This is RTC section 19306. Subsection A, no credit or refund shall be allowed or made after the period ending 4 years from the date the return was filed. And there's some text after that. But that is what I would consider the first prong of the statute of limitation bar. All right. It's 4 years from the date a return was filed, or a date, if you read further down, if someone doesn't file a return, a date of prescribed filing of the return. All right. And the second prong is 1 year from the date of overpayment, whichever period is later. Okay, so the first prong deals with the actual filing of a return or the requirement to file a return. And the second part deals with actual overpayments. Right. So let's look at this statute in the context of my facts. And let's turn to the first page of my handout. And I've entitled it Statute Unclear or Inapplicable. Right. The statute speaks of refunds. Technically, I'm not seeking a refund here. A refund implies the actual payment and the return of a payment. I'm seeking restitution of funds that were obtained through an involuntary collection. We're going to get into that in more detail later. But all of this money, virtually all of this money, came from the foreclosure of my home, and some of it may have came from bank levies as well. But all of it was involuntary. None of it was the result of any voluntary payments. Does the statute deal with that situation? I don't see any reference to a collection or the collected funds in the statute. The statute speaks of returns being filed. Well, I didn't file a return, and I think it's uncontested that I had no obligation to file a return. So that doesn't apply. The statute speaks of an overpayment, right? When it says in the second prong, 1 year from the date of overpayment. Well, I never made any payments. How is there an overpayment if I made no payments? What we have here is a pure collection. So that's my first point. The statute is either unclear or just inapplicable. My second point under the legal analysis. This is the second page of my handout. There's no direct case precedent here. And what I mean by that is, as far as I can tell, and again, if people have more information, I'm all ears. I'm working off what I did, my own research, and the research that was and the cases that were provided in the respondent's brief. But I don't see any case that has all the facts that exist in my case. And I've listed those facts here, the salient facts. No hard income, no tax liability, no obligation to file, no documentation of an income stream, either from a W-2 or from a 1099, no voluntary payments or withholding, it's a pure collection case, and no notice of any allocation of the monies collected to the disputed tax years. Now, several cases were cited by the respondent in his brief, and those cases, most of them are statute of limitation cases, not all of them actually, but most are, but none of them have the facts that are similar to mine. If you look at a Gillespie case, there was an obligation to file in that case, and the taxpayer actually made a payment and sought refunds. So it wasn't a collection case. The Dom case is actually a gift tax case, a federal gift tax case, where taxes were filed, a payment was made. It's not a collection. There's a federal case called the Prusner case, which is actually an estate tax case, right? Not an income tax case, and not even a statute of limitations case. I mean, it's really a case that stands for the proposition that agencies can set very fixed rules, right, that have to be honored. But it's not a statute of limitations case. It's a case in which some of the parties didn't have complete attachments to their filing of their federal tax returns, federal estate tax returns. The Kornblith case is a gambling case. Okay, so it's involved withholding. Again, not a collection case. So I can't find any case really that deals with a pure collection and no obligation to file. Those are the two key elements. Let's flip the page. And let's go to my third point here, in which I try to apply the statute, if we can. Right? At least coldly apply the statute to these facts. First of all, there's no filed return. So the first prong of a 4-year bar can't apply. Right? So that bar can't apply. The second point is, after 1 year from the date of overpayment, well, no payments were made. So how does the 1-year bar apply if no payments were made? There can't be any overpayment. Now, FTB is taking the position that a collection is a payment. I think that's a torturous use of the definition of the term payment, but let's go with that for the time being. Let's say even if a collection is deemed a payment, what triggers the 1-year bar is overpayment, not actually the payment. So when was the actual overpayment? There was no credit in my account until the abatement took place. When we went over the facts, the abatement didn't take place until late December 2020. The money was collected in 2015. So you can't really have an overpayment until you actually create a credit. Right? In fact, if you had looked at my account records, right, if you look at the P&L of my account prior to the abatement, it would show a liability and the payment of the liability and the extinguishment of the liability on my records. But it wasn't until late December 2020 that liability was extinguished, and that is when the overpayment took place. Now, my request for a return of the money didn't take place also until December. So you could argue if overpayment is the trigger for a 1-year bar, I'm within the 1 year because the overpayment didn't take place until the liability was extinguished in December 2020. Fourth point, mistake and overcollection. I'm going to quote from the respondent's brief here because it's pretty well written. Overpayment is a claim for a refund after the taxpayer makes a payment, whereas overcollection occurs when the amount collected exceeds the amount due. So what you have here is a very clear distinction between payments and collections. Payments are made by taxpayers. Collections are something that are executed by FTB. Right? They're very, very different situations. And the statute of limitation does not apply to overcollections. That's black letter law, right? And there's no dispute to that. All right. What we have here is an overcollection, all right, or an improper collection. It is entirely involuntary, right? The cases that are cited all dealt with situations. The cases been cited in the brief by the respondent all dealt with situations where some payments were being made by the taxpayer. Here, I made no payments. So this is a clear overcollection. It's also a clear mistake, right? It's a mistake to take money which is not owed. Now, the respondent points to a technical advice memo, 2001, and a specific example 5 in 2001 of this technical advice memo. If you have a chance, you might want to take a look at it. It's really a short read. But essentially, we have a situation in which the taxpayer, I think it's a hypothetical situation, actually. I'm not sure about that. But in which we have the taxpayer claims a mistake because there was an error in the W-2. In that particular example, the FTB claimed that's not a mistake. The error in W-2 is not a mistake. And if you read that example very, very closely, you'll see that what really turned that particular case was the failure of the taxpayer to file in that example. Right? That's what vitiated the so-called mistake in the W-2. These facts are very different than mine. First of all, there's no W-2. There are no payments, and there's no obligation to file. And I'd like to point out, if I haven't already pointed out, if you notice from the account comments and from my conversations with Jennifer Sorensen, probably the most salient point that demonstrates, that demonstrates the argument that these funds should be returned is no obligation to file in connection with a pure collection. Okay, and let's go to the last point here, my last legal point. This is the delayed discovery rule, right? And you can see this rule right in the California Code of Civil Procedure. I quote, this is section 33(8)(d). An action for relief on the grounds of fraud or mistake, the cause of action in that case is not deemed to have accrued until discovery by the aggrieved party of facts constituting fraud or mistake. Well, we don't have fraud here, okay? But what we certainly have is a mistake, and the overcollection is a clear mistake. I did not learn that the money from the foreclosure was allocated to tax years 2011, 2012, and 2013 until my initial conversation with Jennifer Sorensen on December 1st, 2020. Right? That is the date, right, in which the statute of limitations should have started. Or another way to say is the statute of limitations should have been told until that particular date. And even my reply brief, I even cited some case law, some federal case law, in which the tolling is, in which a court holds that the tolling is especially appropriate in restitution cases to prevent unjust enrichment. Well, that's kind of what we have here, right? There's no payment here. This is a pure collection. And what I'm seeking is restitution to prevent the unjust enrichment of FTB obtaining over $120,000 that they were never entitled to. So let me just summarize. I think I'm almost done here. I suspect I'm within my time. But I'll summarize and say there are 5 legal issues that support the granting of this appeal. First, the statute doesn't apply. the statute applies only to filed returns and payments made. There was no filing here. There was no duty to file. There were no payments made. Second, there's no direct precedent that applies to my facts. In my case, there was no hard income, no tax liability, no obligation to file, no voluntary payments, and no notice of allocation. Third, even if you do apply the statute, it's possible to fit, all right, to fit these particular facts into the 1 year overpayment provision of the statute, because the overpayment didn't occur until December 2020. It didn't occur until the tax liability was extinguished in December 2020. So therefore, I fit within the 1 year statute of overpayment. Remember, the statute's not triggered by payment, it's triggered by overpayment. Fourth, mistake and overcollection. It's very clear that statute of limitation doesn't apply to mistakes and overcollection, right? The TAM example 5 is very different facts than what we have right here. There was a duty to file in that case. I had no duty to file. Finally, the statute pulls for discovery of mistake. December 1st, 2020, in my conversation with Jennifer Sorensen, I learned of the mistake. The money was overcollected and applied to years in which there was no tax liability. The appeal should be granted on these grounds to prevent unjust enrichment. That concludes my presentation.
Thank you, Mr. Hyatt, for your presentation and testimony. Does the Franchise Tax Board have any questions for Mr. Hyatt?
Joel Smith, no, I do not have any questions.
Turning over to my panel members to see if they have any questions. Judge Hosey, do you have any questions for Mr. Hyatt?
No questions at this time. Thank you.
Thank you. Judge Ridenhour, any questions for Mr. Hyatt?
Also no questions at this time. Thank you.
Thank you. I also do not have any questions. Thank you again, Mr. Hyatt. Mr. Smith, it is now your turn to make your presentation. You have 15 minutes. Please proceed when you are ready.
Joel Smith, thank you. Again, this is Joel Smith with Franchise Tax Board. Good afternoon. As has been mentioned, the only issue on appeal today is whether appellant filed his 2011, 2012, and 2013 claims for refund before the expiration of the statute of limitations. This is a straightforward statute of limitations appeal. Respondent issued demands for all tax years based on information it received concerning appellant's payment of mortgage interest. Appellant did not respond to any of those demands. Then under Revenue and Taxation Code Section 19087, respondent issued valid notices of proposed assessment estimating appellant's income. Appellant did not protest any of those proposed assessments. Once each of the NPA's proposed assessments went final, respondent commenced with collection action, and respondent received final payment for the 2011 and 2012 tax years on July 10th, 2015, and final payment for the 2013 tax year on March 27th, 2017. Appellant then filed claims for refund for each of the tax years on March 15th, 2021. As appellant explained during his case in chief, under Revenue and Taxation Code Section 19306, appellant had until 4 years from the original due date of each tax return or 1 year from the date of overpayment to file a claim for refund. As has been explained in respondent's opening brief, appellant failed to file claims for refund before the statutory dates under Revenue and Taxation Code Section 19306 for all tax years at issue. As for appellant's argument as it relates to an overcollection. First, the assertion that Estate of Gillespie is not applicable or relevant is unfounded. Estate of Gillespie is very much on point. That is was the result of assessments based on estimating income from a business license. FTB received payments through the collection efforts, and they were deemed to be barred by the statute of limitations. So here, the argument that these are an overcollection is not correct. As the technical advice memorandum 2007-01 explains, an overcollection occurs when the amount collected exceeds the amount actually due under the law as a result of a clerical or mechanical error. To quote the technical advice memorandum, collection of amounts pursuant to a valid assessment will never result in an overcollection. Here, respondents' valid assessments were based on proper estimates of income under Revenue and Taxation Code Section 19087. Respondent pursued collection action after the valid assessments went final. In conclusion, based on the record and California law, respondent properly denied appellant's claims for refund. I can answer any questions the panel has. Thank you.
Sorry, Judge, I cannot hear you.
I'm gonna go ahead and try again. Testing again. Okay. We're gonna go ahead and take a 5-minute break. Let me try to fix my audio, unless you can hear me now.
I hear you fine now, sir.
Okay, perfect. Not sure why it's going in and out. But thank you, Mr. Smith, for your presentation. Going to turn over to my panel members to see if we have any questions for respondent. Judge Hosey, do you have any questions for respondent?
No questions, thank you.
Judge Reidenhauer, any questions for respondent?
Actually, I do have one question, please. This is Judge Ridenour. I noticed in the NPAs you have a certain amount for like 2011, $55,054.07. But then when you go into the current values displayed, you collected 57,758.77. So there would be, according to the two documents, an overcollection. And so I was wondering if FTB could give their, explain that or, please.
Joel Smith. Yeah, so for example, Exhibit C would be the 2011 NPA showing the 55,000. And then Exhibit D shows the amount collected of 57,000 and change. That difference would be additional interest that is accrued on the account since the issuance of the NPA. So basically the interest from the issuance of the NPA to the payment date.
Thank you very much for the clarification. That's my only question. Thank you.
I do not have any questions for respondent. Mr. Hyatt, it is now your turn to rebut the respondent's arguments. and give your final statement. You have up to 5 minutes. Please proceed when you are ready.
Yes, thank you, Your Honor. Just a couple of points. I believe Respondent's counsel mentioned that Gillespie was a good precedent. Gillespie wasn't a collection case. I'm reading Gillespie right now, page 3, item 11. On December 15, 2013, respondent received appellant's payment in the amount of $21,656. So it was a payment case, wasn't a collection case. And it also was an obligation to file. So Gillespie was very different than my fact pattern. Secondly, the Counsel Smith, he mentioned several collection notices, or at least he filed some collection notices. I think it's fair to say something about those notices. First of all, I don't think any of those notices show, or there's any evidence anywhere that I actually received any notice. I mean, these were all sent by mail, as far as I can tell. Some of them were sent to the wrong address, but some were sent to the address I lived in. I had a home in Los Angeles. I was not in Los Angeles for much of that 2011, approximately 2010, after I left the firm, to around 2018. I was in New York quite a bit. My mom was ill during that period, and she passed away in 2018. So I don't recall receiving those notices. I wasn't there actually to receive those notices, to some extent. People were there for me. And also these notices in no way, I didn't see any evidence of any notice that actually showed a collection of funds from the foreclosure. I saw notices that showed delinquency, again, through the exhibits. I saw notices that showed an amount owed, an assessment. I don't see any notice of any type of actual collection. I found out about the collection on December 1st, 2020. And I think the record's clear on that. That's when I learned of it, right? And that is the date, if we go with the delayed discovery rule, we use for the tolling of the statute. I'm not sure what happened in this particular case, I'll be honest with you. When I requested the money be returned to me, the money that was taken via the foreclosure, apparently, according to account records, several people approved approved the return of the funds. But then it also appears that one person stopped it. And we don't know who this person really is, and whether this person was using a legal analysis, or whether even there was any legal review of this situation internal to FTB. When I spoke to Executive Advisory Services later, they also, which is an office that works with the taxpayer advocate, they also said their opinions were consistent with Complex Accounts, Ms. Sorensen, and saying that they would have a different view, that this money should have been returned because it is a mistake. Once again, I don't know what happened. I think this case screams more discovery, more depositions, more email. There's only been a few emails that have been produced, but let me say this: if this case gets to federal court and somebody tells a judge that email has been purposefully destroyed, FTB is going to be looking at exposure much higher than what they may owe me as a claim. 10 or 20 times as high. You destroy email in federal court, you're looking at a 7 or maybe 8-figure fine. So hopefully Joel can find some email somewhere down the road for the benefit of FTB. Anyway, that's all I have. I want to thank everybody in the panel. I want to thank everybody at FTB. I want to thank Joel, because Joel has been very courteous and very professional in providing me the information I asked for in this discovery, and he's been very honest and very professional. Let me say that again. And thank you for giving me the opportunity to be heard.
Go ahead and turn to my panel members for any final questions for either party. Judge Hosey, any questions?
Judge Hosey, I do have a quick question for the
Sorry, I'm having a
appellant.
little trouble hearing you.
Can you hear me now? This is Judge Hosey.
That's better.
Thank you. I do have a question for clarification for the appellant, Mr. Hyatt. You said you own the LA property. Can you clarify what dates you resided there?
Well, I owned the property from, I believe, 2005 to the foreclosure in 2015. I believe that's correct. That's when I owned the property. After I left my firm in 2010 and was unemployed, I still resided there partially, but I spent most of my time in New York.
Okay, thank you, Mr. Hyatt. This is Judge Hosey again. I have a question for Mr. Smith as well for the Franchise Tax Board. Can you tell us about the notifications that went to the LA property and whether it was properly noticed, Mr. Smith?
Joel Smith. So I'm guessing you're referencing Exhibit O. So this is the first. It's been mentioned that these were maybe not received. There's nothing in the record to suggest the FTB had notice of another address, meaning they were issued to appellant's last known address. And as appellant's Exhibit 7-1 shows in 2015, there is a back and forth between FTB, the foreclosure trustee, as it relates to appellant having notice of these payments coming to FTB. So in conclusion, there's nothing to indicate these documents were returned to the FTB as they were sent to the wrong address, and appellant seems to note that they were sent to his California address.
Can I be heard on this as well? This is again Clifford Hyatt, the appellant.
And Mr. Hyatt, this is
Done
Judge
with
Hosey.
your answer?
Yeah, I just have one thing to add to Joel's comment. With respect to my knowledge that payments were being made to FTB. And the foreclosure of my home, let me make this clear, I owed money from 2010, right? And I was well aware that money for the foreclosure of my home was being used for 2010. I owed a considerable amount of tax money for 2010. And so that's where that was my understanding, that the money from the foreclosure was being used for 2010. I didn't learn about the money from the foreclosure being used for 2011 or 2012 until 2020.
Thank you, Mr. Hyatt. Thank you, Mr. Smith. I think that answers my questions. That's all I have. Thank you.
Judge Ridenhour, any questions for either party?
I'm sorry, did you ask? This
Yeah,
is Judge
sorry, did you
Ridenhour.
hear me?
No.
My
that's
audio
okay.
cutting in and out.
Sorry. And this is Judge Ridenhour. No questions. Thank you.
Judge Hakopchikian speaking. Mr. White, I do have one question. Exhibit 7, which you provided, had the account comments. On page 1, line 4, there's an entry from May 13, 2015. It says the taxpayer has protested disbursement of the funds in 2015. Do you recall any of the facts and circumstances around that protest?
I believe, again, we're going back a little bit in time, but I believe that's generally accurate, in that when I first heard that the money from the foreclosure that was being used to pay my back taxes, I sort of routinely filed an objection. But I knew all along, I owed money from 2010. All right, and I actually got money from the foreclosure back for over and above the 2010. I got some surplus funds returned to me as well. So that was my understanding, all right, that the money from the foreclosure in 2015 was being used to pay 2010 taxes, which I did owe.
I don't have any other questions. Does either party have any questions for the Office of Tax Appeals before we conclude the hearing? Hearing none, we are ready to conclude this hearing. This case is submitted on September 27, 2022, and the record is now closed. I want to thank the parties for their presentation today and Mr. Hyatt for his testimony. The judges will meet and decide this case based on the arguments and evidence presented to Office of Tax Appeals. We will issue our written decision no later than 100 days from today. This concludes the last hearing for today. Thank you all for your participation.
Thank you, Your Honors.
Thank you.